Golf Central on YouTube, brought to you by the Chrome Soft Golf Ball from Callaway.
Hello, I'm Anna Jackson, and this is your Golf Central update. So a trial date has been set in regards to a lawsuit filed by LIV golfers, including Phil Mickelson and Bryson DeChambeau, against the PGA Tour. U.S. District Judge Bethel Freeman has set a tentative date for summary judgment for July 23, 2023, with the trial date expected to begin on January 8, 2024, months later than some had anticipated. So updating the timeline of events since the first players left for LIV Golf back on May 31st. They played in that England event and were suspended by the PGA Tour on June 9th. The antitrust suit was filed against them on August the 3rd. The temporary restraining orders for 3 players to play in the FedEx Cup was denied 1 week later. And summary judgment hearing for the suit is scheduled for next July. Jody Balsam, sports law professor at Brooklyn Law School, joined Jaime and Damon Hack earlier on Golf Today to talk about what we learned over the weekend.
One is that the players, the LIV Golf players down to 9, are not going to pursue any form of preliminary injunctive relief between now and that trial date. So as you know, they sought emergency relief in the form of a TRO that would have covered just the FedEx Cup tournament. They were denied that relief. They still had the option of pursuing relief that would take them through the entire year and a half until trial and prevent the PGA Tour from excluding them from its tournaments. They decided not to do that. They decided to allow the PGA Tour to continue, or rather not to ask the judge to stop the PGA Tour from excluding them from tournaments. So we've now got a year and a half period until the trial date in which the PGA Tour can continue to do business as it hoped it could, by excluding anybody who is participating in LIV Golf tournaments. There will be no request by those golfers for interim relief. So that's a big concession by the LIV golfers. What comes along with that is an equally big incentive to move this case quickly to trial, because the sooner they get what they hope to be a trial ruling in their favor, the sooner they can resume playing for the PGA Tour. So what's going to happen between now and January 8th? So there were 2 things that we learned, 2 additional things we learned from the status conference last week. One, this trial schedule is still very ambitious. You may remember that the judge originally tried to schedule the trial for August 2023, and she was talked off that ledge by the PGA Tour's lawyers, reminding her that that is precisely when the tour hits one of its critical series of events, the FedEx Cup, and everybody who might testify at that trial, senior PGA Tour executives, top ranked players, would be consumed by the FedEx Cup events and wouldn't be available for trial. That's one of the main reasons she moved the date back to January 2024. So what's the third thing we learned is what's going to happen between now and January 2024. There's going to be what is called pretrial discovery. That is, the parties in this lawsuit are allowed to request from each other documents and interviews with witnesses, known as depositions, to learn about the positions, the facts, the ecosystem of golf that would support or deny relief under the PGA, under the LIV golfers' claims. And that discovery can be very time-consuming and disruptive. And in fact, it is a very rare antitrust lawsuit that could get through the required discovery in as short a time frame as this judge has set forth. In fact, one of the lawyers in last week's status conference made the point that the average time to trial in the Northern District of California for a civil case is well over 2.5 years. So she's trying to do it in 1.5 years, and I wish her luck.
Jody, how much did the principles covered in the TRO that was successful for the tour, even though the judge said this is not the antitrust case at large and we shouldn't draw any conclusions about it having an effect, in your opinion as an attorney, will those same principles be important going forward as the trial starts to get scheduled?
Yes, absolutely. Those principles will be a key source of the kinds of questions and requests the parties make of each other in the discovery process. So the parties are now polishing off their document requests. They're going to ask for a range of materials from the other side that will help them explore the legal questions raised in that TRO hearing, including, is the PGA Tour monopolist? Have they exercised monopoly power in a way to exclude or undermine potential new entrants in the world of elite professional golf? What have the members of the tour and the executives who run it said to each other about the LIV Golf entry? Those individuals will all be deposed. That is, they'll be examined under oath in advance of trial to discover information that will either support or defeat those legal issues.
Well, let's take a look at the final leaderboard from the BMW Championship. Patrick Cantlay defends his title. Scott Stallings finishes one shot shy of forcing a playoff, so close to his first win in more than 8 years. Scotty Scheffler and Xander Schauffele in a tie for third. Schauffele's missed birdie putt on the final hole actually allowed Scheffler to remain at the top of the FedEx Cup standings, but it was Cantlay's week in Delaware.
I think every time, I've tried to defend, I don't think I've been able to do it, but it's something that you definitely circle on your calendar as something you want to do. And these golf courses, like I said earlier this week, reminded me a lot of each other. And, I was glad not to go 6 holes in a playoff today.
If you could take us back to 17 for a minute, your thought as the ball was in the air, and were you surprised by it all?
Yeah, very much so. I thought hitting it on that line, it would for sure be in a bunker. Got an excellent break. Maybe one of the best breaks I've ever gotten coming down the stretch. And when you get a break like that, you need to pay it off. And fortunately, I did.
Patrick, you said the other day that you felt the format at Eastlake was still a little strange to you after a few years. And yet you seemed to handle it just fine last year. And now this year, obviously, a little bit of a different situation. We just wonder if you could talk about putting that aside just to be able to get the job done.
Yeah, I think how I feel about something doesn't necessarily affect my performance one way or the other. I try to be as objective as possible. And that tournament, especially with the staggered start, I think rewards somebody who doesn't lose sight of the fact that they're still playing a 4-round golf tournament and they need to lay down the best 72-hole score possible. And then, you can start to look at the leaderboard on Sunday on the back nine. But until then, you're just trying to shoot under par every day. And for me, a mantra of mine last year was to stay in the moment.
Ben, go ahead.
Mate, why do you think no one has defended the FedEx Cup?
Good question. I would maybe a Tiger injury. I expect him to have almost every record, so it's kind of surprising. Even I knew that, but surprising that he didn't has never defended. But I think with it being a year-long race, it's a difficult goal to achieve, because it's not just one tournament. You have to put yourself in position for the whole year, and then that week you have to perform as well.
Well, 5 players have successfully defended their titles this year on the PGA Tour, the most in a season since 2007. In addition to Cantlay, Victor Hovland, Sam Burns, K.H. Lee and Rory McIlroy are on the list. McIlroy defended his 2019 RBC Canadian Open title, the event that wasn't played in 2020 and 21 due to the COVID-19 cancellations. Thanks for watching. As always, this is your Golf Central Update.